Any mention?
May it please your lordships. My lord, this is a writ petition, my lord, where I have filed an application for impleadment.
For?
For impleadment, my lord. There is a sense of urgency in the sense, my lord.
What matter is this?
This is, my lord, with regard to, my lord, suspension of Siddharship of Nongpo Elaka. Now, my lord, I am representing, my lord, out of 6, my lord, 5 Lindo electors. Now, they have lost confidence on him. These were placed before. Somehow, these matters were not before this court. So, my lord, there is a sense of urgency taken up on Friday.
For impleadment?
For impleadment, my lord.
Who's the petitioner here?
Assistant now here.
Lordship, so far as the Lindo is concerned, Lordship, they are from a body, Lordship, the Sinjuk. Now they are already a party in the petition.
Oh.
They are the complainants, Lordship. They are already a party, Lordship.
No, I have explained all those things. Lordship will see. Lordship will take it up.
And so far as the confidence is concerned, that is not the subject matter of the repetition, Lordship.
That's it. Lordship will hear me.
Yes, let them come. The more the merrier, yes.
Lordship.
Please, Your Lordship, I beg to mention item number 25, Lordship.
Number?
25. Let this matter come up after vacation.
Who's the other side?
I'm there, Lordship.
You for the petitioner, you have no objection?
No objections.
After vacation, yeah.
Lordship, only the interim order will be continued, Lordship.
The interim order until further orders. Mention the respondent for a request of the respondents. Also, we have the respondent. Yes.
Please, Your Lordship, I beg to mention item number 26 on behalf of Legal Aid Counsel, Ms. Anjishla.
Yes.
Lordship,
Let
Madam
the
is on sanction leave.
Let the matter come after the vacation, Your Lordship.
Yes.
Your Lordship, I beg to make a mention of item number 33, Lordship. I pray the matter may come up after winter vacation.
Who's the other side? Have you informed them?
No, Lordship, I have been looking for them, but I cannot find
You
them.
inform them first, otherwise you can't mention it. Yes.
Lord, I beg to mention item 21 and 22, my lord. Lordships, we kindly have this after vacation. Mr. Paul is on the other side in one matter.
Item number 22.
And in 21, Mr. Warjari is on the other side. I've informed them.
21, 22.
Yes,
Okay, after vacation, yes.
indeed.
On the prayer of, you're for the respondent in
my lord.
21,
Respondent Muda, my lord.
moved on both the cases.
Yeah, both the cases.
Yes.
Please, Lordship, I beg to mention item number 23.
Number?
23. I pray that the matter may come up the vacation, Your Lordship.
Yes. Yes.
I would like to mention item number 29 of the hearing list. Because this matter was, there's a similar matter which is being heard before the Bombay High Court relating to the IP. That matter has already been heard and the matter is pending judgment.
Oh, that regarding that the land.
Yes, sir.
Okay.
After the holidays in that case.
After holidays.
Obliged.
You mean it was heard more than a month ago?
Yes, sir. It's taken some time now. I don't know why.
Yes.
Supplementary list, item number 1.
Corrected the other errors.
Yes, my lord.
Check the translation carefully.
Yes.
Will you issue notice?
My lord, only one limited issue. Your lordship may issue notice, my lord.
Yeah.
My lordship, because this is a project, Shillong Dawki Highway, my lord, and then the PIL is also in PIL. This project is being monitored, my lord. Certain directions have been passed in this PIL, my lord. I would just wish to praise the direction, and remedy lies under section 64. If they have grievance, my lord. Kindly see the last page, my lord.
Yes.
All steps had been taken to facilitate the construction. Land had been duly acquired and handed over to NHIDCL. Some elements are obstructing the construction and also filed cases We direct the respondents shall jointly and severally ensure that afforestation work, my lord, and 2, construction of highway, which is of paramount welfare of state and which is of long overdue, proceed with expedition, complying with all earlier directions, my lord. Orders have been passed time to time, my
No,
lord.
they are not obstructing the construction highway.
They are asking for the relief, if your lordship will see.
They are saying that because their plantations have been destroyed.
Yes, my lord. Kindly see the. Yes, your lordship. Kindly see the prayer. And everything done long time back, my lord, unexplained, my lord. Consider approved a direct respondent to compensate amount of 1,25 lakh rupees. So they are asking for damages, my lord. And 2 is nature of mandamus to direction.
Earlier one didn't have this prayer.
Yeah, same.
Same prayer.
Damages, they are asking for damages, my lord. In the writ code, they are asking, and the remedy for damages is 64, my lord. Section 64.
Notice.
Yes, sir.
Yes, the case will take a different direction because only with regard to hurt Mr. S.M. Suna, the counsel petitioner, Mr. Advocate General, Dr. N. Muzika, which also is present on behalf of respondents
1 and 2.
1 and 2. Advocate General is present with so and so on behalf of respondents. Remaining respondents is 3 to 12. No further was called for. List after.
One submission, my lord. Your lordship may observe that project there is because the relief is confined to damages.
Yes, it is noted that the relief claim petition is confined to damage caused to the plantations of alleged damage caused to the plantation of the petitioners, which, however, is not with regard to any obstruction being caused to the smooth progress of construction of the highway.
Grateful.
Obliged.
Item number 2.
The petitioner, my lord, herein is a 2011 junior grade MCS officer, my lord. But in 2015, he was implicated in a criminal case, my lord, when he was, my lord, the BDO of Jirang. In that particular case, my lord, where the police officer shot himself. So, my lord, thereafter, discipline proceedings were drawn, and he was placed under suspension. Now, during suspension, he was implicated in another. Yes, my lord, in 15. Now, in another criminal case, my lord. And there also, disciplinary proceedings were drawn. Now these...
a different case?
Different case, my lord. During when he was...
What was the offence?
My lord, his cook, my lord, was found hanging around the scene, my lord, where a bomb was planted, my lord, in the MPSC building, my lord.
His cook?
Yes, my lord, was found wandering around that area, my lord. So he was also implicated, my lord.
How?
My lord, I really don't know, my lord. Those cases also leading nowhere. There in the statements also his name has never come out. So, my lord, both the trials are pending, my lord, and the DPs also, my lord, not moving forward. Now, in between, my lord, his juniors have been considered for promotion and have been promoted. My limited prayer is to consider his promotion, my lord. So, at this stage, I'm only praying.
He's still under suspension also?
No, my lord. He has joined, my lord.
What happened to department proceeding?
Your Lordship, let me have instruction, Your Lordship. In this,
let notice be issued.
Only thing, Your Lordship, here in the petition they have sought for redetermination of the seniority, Your Lordship. So those people who will be affected are not before Your Lordship.
No, my lord. Firstly, I'm saying consider my promotion and restore my seniority.
Certainly, that will be
as and when my.
But then the criminal trial is going on.
Yes, my lord. But it's my lord, evidence stage, my lord.
No, but there's an inquiry into that officer who shot himself.
Lordship, let me have instruction, Your Lordship.
Is that incident in
yes,
somewhere in
Jirang,
regarding those coal trucks stopping
Lordship,
yes,
and
he was shot.
Yes.
What was the report?
That police personnel, Your
was
Lordship.
killed. You don't know.
But as for the charge sheet, it was suicide, and he has been implicated, my lord, because that morning he had made a call to him, my lord. He was a BDO, my lord.
Okay. Heard Mr. Philomnongri, issue notice. Mr. Ndifilai, that EG with so and so is present, except notice on behalf of
1 to 5, Your Lordship.
No, 1 to 4.
1 to sorry, Your Lordship. 1 to 4, Your Lordship. Yes.
To serve number 5.
Yes.
A person to serve copy of the writ petition on the Standing Council for number 5. A list after locations for
Apply, Your Lordship.
instructions or affidavits.
Deeply, Your Lordship.
Item number 3.
May it please your lordship, this is a pension matter, your lordship, where the petitioner
When did he retire?
retired on 30th 9 2024 and
Retired
31st.
30th 9/24. You've come writ petition now.
Yes, lordship, because they did not start their process also, your lordship, for the pension.
I don't. This is premature because many people after 2 months after retirement doesn't mean you come to court running for pension. Can understand if you've been deprived or something. Yes, Mr. Sen.
I'll take instructions, my lord.
This part was your MS Kharmandai.
Yes, your lordship.
Yes, for the petitioner issue notice, Mr. SN is present and accept notice on behalf of
Sole respondent, my lord.
sole respondent. He please call allowed 3 weeks time of the instructions. This concern, so yes.
Acknowledgement.
Much obliged, your lordship.
Item number 4.
May it please the Lordship. My lords, there is a writ petition that is pending before this court already. Now, what had happened, my lords, that I was originally the Gaubura of a certain village. Now, I was removed, my lords. I came before your lordships, my lords. There was a direction to conduct a fresh elections. I contested the elections. I was successful in the elections. Now, what had happened is, my lords, thereafter, again, the people who had originally removed me through backdoor, my lords, again, some complaints filed. Unfortunately, my lord, the district council, without serving us a copy of the complaint or, my lords, even calling for a response from me, decided to conduct some kind of a spot inquiry, which admittedly they could not because of lack of space or otherwise. Now, my lords, the reason for filing this miss case is I have come across a notice, my lords, which has not been given to me, which is at Annexure 1. Again, another complaint has been filed, my lords, and again the same exercise is being done, unfortunately, by the district council by trying to hold some kind of an inquiry against me without providing me a copy of what is there in the complaint, my lords, or without my participation in the entire inquiry in the first place.
What happened to the other case?
That the main writ petition is pending before your lordship.
It's pending, my lord.
What any interim orders there?
No interim order, my lord, but a spot inquiry which was supposed to be held, my lord, it was not conducted because of the law and order problem, my lord. We have filed an affidavit to that effect.
You mean to say there's a continuation of the earlier of the same writ petition?
Yes,
Same spot inquiry.
Yes. So now, my lord, we have issued a notice dated 21st November 2020.
Where is that?
Annexure 1, my lord.
Annexure 1, my lord. To conduct an spot
This is the
inquiry.
27th of November.
27th, my lord.
Yeah. Copy even marked to you.
It is there, my lords.
Abdul Salam, yes.
Lordship.
So why are you opposing it?
I am not opposing it, my lords. I am only saying that if they are to hold an inquiry, my lords, it cannot be behind my back.
We didn't receive. Where did you get this notice from then?
My lords, this is from the district council.
No. I mean, this notice is the one marked to you, correct?
No,
Your name
this
is
is not the
Abdul
one
Salam.
marked to me, my lords.
Abdul Salam.
Yes, my lords.
Who's Abdul Salam then? You're the Gaubura of the
I am the Gaubura, my lords.
Nondichor,
Yes, Nondichor.
but you're mark on number 3 in notice.
My lords, the copy is shown marked to me, but I have never got it.
Okay. Yes, Mr.
My lord, we will take it.
If at all they are to do something, my lords, it has to be with my participation. It cannot be behind my back.
This case number 214/2024 WPC 325/2023. By this submissive application, the writ petitioner stroke applicant prays for directions to issue to respondents to furnish copies of complaints, if any, with regard
Along with all supporting
with
material, my
regard
lords.
to a spot inquiry that is proposed to be held on
13th, my lord.
13th of December, my lords.
13th 12/2024. Stop. Next was submitted Mr. K. Paul that the proposed spot inquiry is not to the knowledge of the writ petitioner, nor was a copy served on him. Stop. He further submits that as the matter is pending before this court, interim orders and some interim protection is necessary so that the petitioner will not be prejudiced in the proposed inquiry. Let the inquiry go ahead. You give
Yes, my lord. Let the
no,
inquiry let it go, my lords. But please,
accordingly, it's directed that before any spot inquiry is conducted by the respondents, next paragraph, the district council or the respondents are to furnish copies of the complaints and other connected materials to the petitioner. As the inquiry will fix on 13th December 2024, the same shall stand deferred to any other suitable date fixed by respondents.
But we'll give them before 13th, my lord. We can supply.
Today is 11th.
11th, my lord.
11, my lords, day after tomorrow.
Then we'll fix
Let it not be a hogwash of an inquiry.
Yes. Then we'll fix a fresh date, my lord, after supplying him the documents.
It's fixed on 14, 13, as the inquiry is fixed on 13. It's deferred on a date to be decided by the respondents after complying with the court's order. Yes.
Well, I may be afforded an opportunity of hearing.
It is understood that the petitioner will be afforded adequate opportunity of hearing in such inquiry.
My lords.
This next paragraph, Ms. K is going to stand disposed of.
Highly obliged.
Yes, item number 1.
May I please, Your Lordship? Your Lordship, I pray for some more time to file my rejoinder.
How many times you taken?
This will be third time, Your Lordship.
Third time. You have objection?
No, Lordship.
Yes. As prayed for the 2 weeks time allowed for rejoinder. Yes, sir.
Much obliged, Your Lord.
Item number 2.
My lord, this is a contempt petition, my lord. They have served us the copy of the affidavit, my lord, which transpires that they're trying to prolong the matter, my lord.
It's not to prolong the matter. It has to be done as per the law, my lord. Demarcation cannot be just made, my lord, in the land.
No, they have.
It's a claim and counter.
Mozadar has already submitted the inquiry report, my lord. They could have simply.
Where's the order? It gives a time frame for the.
Yes, they asked for 45 days, my lord.
Where's the?
This annexure 1 of their affidavit, my lord.
Oh no, 1 second. Where's your
contempt, my lord?
Petition?
It's annexure 2, my lord.
Yes, Mr. Day, you undertook to.
Yes, exactly. Exactly, my lord. May kindly come to my affidavit, my lord, page 21B, my lord. Page 21B, my lord. Para 2, if my lord may. Kindly come to para 2, page 21B, my lord.
21B, yes.
Now, my lord, may kindly see para 2, following the order of this of the Honorable High Court, this court deputed Mozadar for spot inquiry demarcation between the two arcing dated so and so, my lord, on so and so, which was submitted its report on so and so. However, since the spot inquiry report of the same Mozadar is not conclusive, a date was fixed for court inquiry into the disputed land, which was fixed on so and so. During my spot inquiry, both the parties were present along with their important clan people. Both the parties submits their map, wari, and other related documents to support their claims. Self also cross-checked from the office record and also visited the pillar of the boundaries of the disputed land physically. As per the record available in the office and between the two parties, the two deep or pillars is not similar, and hence the boundary dispute between these two.
Once you file an application for extension of time.
My lord, it's not that, my lord. It's not that we are sitting over the order of this.
No, whatever it is, if you can't complete within the scheduled time.
My lord, here what happened, my lord? Now, my lord.
We understand that.
Because of the order of this honorable court, my lord, we have to comply with Dore Sangma. Because it become an acting law.
About Dore Sangma anymore, my lord.
Then we'll file an application, my lord, for extension of the time, my lord.
We won't pass orders,
My lord, I will file an application.
It has been filed by the respondents, pleading the delay in complying with this court's order. list the matter after vacation, which is for rejoinder of any.
I'll oblige, my lord.
Item number 3.
Not in this case, there's a miscellaneous application 13 of 2024 where they're sought to be impleaded as a party.
Your Lordship, in this matter, I pray for that this matter may come after the vacation, Your Lordship, as the conducting counsel is having some personal difficulties.
Who's the conducting counsel?
Kishore C.H. Gautam.
No, it's for Impleading. For Impleading.
Yes, sir.
Where's the miscase?
We filed an objection as well to it.
Why are you objecting?
Because he has no role to play in this case. Absolutely no role.
Have you have objection also?
No,
I'm the one who has filed the
Impleading
application.
They informed me beforehand.
Yes, MS Arakhashi, prays the matter be taken after vacation as the conducting counsel is indisposed. Yes, according to the matter, as praised.
Item number 4.
Yes.
My lord, the AG will be apprising because on the last occasion, Lordship has put a query if those coal left, my lord, the order with regard to what will happen to the status of the coal.
Yes, this is a seizure under 21.
My lord, yes.
So that means it's with the court only.
My lord. So AG has, when the full bench matter was taken up, AG has apprised Lordship with the issue with regard to the query Lordship has put.
So what do you want today?
My lord, AG was supposed to answer to Lordship's query, so I've already informed me the matter has been called.
So far as, my lord, coal is concerned, my lord, the coal which are auctioned under section 21 of MMDR Act is concerned, my lord. There is a procedure prescribed in the Act itself where the under section 21, if your lordship will see section 21 of MMDR Act, my lord.
Yes.
Section 21, and this was upheld by the Supreme Court also, my lord, in all the Masa, but who 21, my lord, whoever contravenes the provisions of subsection 1 of section 1A of the section 4 shall be punishable with imprisonment for term which may extend to 5 years, with fine which may, my lord.
Yes.
Kindly see 4, my lord. Whenever any person raises, transport or causes to be raised or transported without any lawful authority any mineral from land, and for that purpose use any tool, equipment, vehicle or any other thing, such mineral tool, equipment shall be liable to be seized by an officer and authority especially empowered in that behalf. So the penalties are imposed under 21(4), my lord, and your lordship has taken note, and cognizance of offence will be taken under 22, my lord.
Yes.
No court shall take cognizance of any offence punishable under this act or any rules made except upon complaint in writing made by a person authorized in this behalf.
No, one thing, Mr. Garfield General, the
Yes,
thing
Lordship.
is that that stage is over.
Yes, my lord.
Correct. This coal has already been auctioned.
Yes, my lord. This
And
was
then-
auctioned pursuant to the order passed by the special court, my lord.
Right, this auction.
Yes, my
The
lord.
only thing is that it's not been.
That now the person
and
is
the
not
and
coming.
The person
Is
also
not coming.
has deposited the money.
Yes, my lord, and he's
but
not.
not lifted the coal.
Yes, my lord. That kind of problem we are facing in the coal.
So what? How do you address this problem?
Now
That coal still lying there.
16, your lordship, matter is coming up before that main matter. In main matter, we will be, because we have got SOP, a standard operating procedure, which has been approved by Kataki committee and we have placed before it.
For lifting of this coal.
Yes, lifting of the coal.
You have to start demarcation
Yes, we are
But
charging
is in
the
the
marriage.
depot,
The marriage, but
is
yes.
the depot, it's lying where it is.
Yes,
It's
my lord.
called.
So now the only option is that the complainant or the officer authorized who has filed the complaint before special court, he will move a special application saying that the coal is not being lifted and therefore kindly permit the authority once again to re-auction. That is the only option we have under this CRPC procedure, because the person who has deposited the money is not coming forward to lift the coal. The demurrage charges will be levied, my lord. But other things, because it is a criminal proceeding, my lord, I don't have power to simply sell the coal without the permission of the court. And direction which has been passed, my lord, by the learned session judge in this court is that the DC will ensure the presence of the buyer, my lord. That those kind of powers do not exist in CRPC or even under special court, my lord. So far as larger issue is concerned, my lord, your lordship is addressing the larger issue in PIL, because lordship has seen that parties have even the file came to me that they have deposited entire amount and they are not lifting. We are
Can the court order the replica petition shall ensure that successful so appear for this court, explain why the lifted auction coal till date?
That power is not there in CRPC, my lord. The power in CRPC is governed by section 173(8) and 190 of CRPC, my lord. So those powers are wholly without jurisdiction. DC or any other officer, at best IU, that is complainant, can be summoned by the.
No, but in an FR, this case.
We have filed the FR.
All FR been filed in the court. There's nothing remains, but
Yes,
the order has been passed asking why the coal has been lifted.
If in the event of filing of FR, my lord,
What are the powers of the court?
under 190 of CRPC, power is three powers are there, my lord. One, it can accept the FR or direct further or close the matter, or it can direct the officer to investigate the matter further, my lord, or it can take cognizance against the accused who are mentioned in the FR or not traceable. These are only three remedies in law which are available to the learned session judge. He has no power to summon anyone, my lord, under the law. Those powers are completely wholly without jurisdiction. So therefore, those are jurisdictional transgression by the learned session district.
You say that you're putting SOP in place with regard to these kind of cases.
No, we have put in the SOP. Yes, in SOP, the problem is in SOP we say that we will issue the mineral transport challan to the successful bidder. Now the successful bidder is not lifting the coal, but he is ready to sell the coal to the third party. And in some cases he has already sold and we have got the agreement. Now we are not permitting the transportation of the coal because the SOP says that only successful bidder can get the transportation challan. But the successful bidder has a right to sell the coal, my lord. There is no bar or in law. Only thing which we are required to ensure that this should not be pilferage or this should not become a tool to do the illegal coal
No, but why should the court facilitate that? Because if he sold it, he sold it.
No, but
who knows? He'll use his own transport challan. Whoever lives the
no,
coal.
but my SOP, my lord, which we have placed in the full bench before your lordship, we say that transportation challan can be issued only to the successful bidder.
Right.
Now, successful bidder has sold it to X, my lord. X is asking for transportation challan from the department. We are not issuing transportation challan because we have filed the SOP where we say that only successful bidder will get the transportation challan. If that part will be modified, there will be facilitation.
If you modify that part, it will give way for more illegality.
No, there will be no.
Then
because
challans will be floating around being sold.
No, my lord.
Sold in the market.
No, my lord. In any event, the successful bidder has a right to sell the coal. That right has not been taken away by.
So your SOP is fine. I mean, successful bidder, he lifts the coal and
now
sells it to anyone.
From pithead only, the successful bidder has sold it to Y, my lord.
Right.
And Y is seeking permission to lift it coal with transportation challan. Without transportation challan, he can't.
Right. But is why? But then in your challan is a provision to show that this auction coal has been lifted from here, buyer is here. You know.
Yes.
Then you have to ask all those other kind of other kind of paperwork. You have to.
No,
but this might facilitate other illegal things like you just get you sell transport challans. You don't know what coal, where it's come from.
No, coal in the mechanism provided in SOP is that they have to follow all the procedures. Even successful bidder or the subsequent purchaser is bound to follow the procedure, my lord, which we have. But since we have said in SOP that only successful bidder will take the transportation challan, we are facing difficulty in giving the transportation challan to even the buyer, because what will happen, my lord, if successful bidder will lift the coal, he will take the coal to X place where he will dump the coal. From there, then the Y will come that I have purchased. Then all those kind of things will lead to complication, my lord. And then right now we have coal at coal depot, my lord, where the coal is already demarcated, designated, and everything is there. Now, and because of slump in Bangladesh and slump in market, my lord, even successful bidder is not in position to lift the coal. They are paying demurrage charges. Out of 15, 8 or 9 they have paid also demurrage charges. Rest of them are not paying, so we will ultimately, we have issued notice. If they don't pay, we will forfeit and seize the coal also. But ultimately it will lead to lots of complication and economic
even in SOP lead to a lot of complications.
Yes,
You should transfer challans to people, like, you know.
No, earlier that Justice Kataki has provided that we will have all kind of security features in transportation challan, etc. That kind, we are going back to Justice Kataki with this issue that we are facing, where the buyer, successful bidder, is saying that it is willing and it has sold the coal.
Okay, we'll pass this matter. We'll leave it for a later date.
Yes, ma'am.
Only thing, we'll pass some directions. It has been submitted by the Learned Advocate General that the state respondents are devising a new fresh SOP with regard to
in the process of
in the process of
it has not been yet finalized.
In the process of drafting a new SOP to facilitate the lifting and transportation of coal that has already been auctioned but not lifted by the successful bidder. In view of this development, let the matter stand over to after vacations. Yes. If he lives in the meanwhile, it's over.
Yes, if the process is and interim order to continue, mirror in this matter.
Interim order to continue.
Item number 5.
But your SOP will get a lot of.
There are issues which we are we are facing practical issues time to time in working out of this.
Yes, if I rejoinder.
Yes, Lordship. Otherwise, this matter also was placed. I got a notice that it was placed to lock adalat also. I've received from my client. I don't know whether.
Yes, sir.
Can you wait it?
It's a matrimonial matter. No.
This pension matter. This
yes, you're aware about that.
No,
you got notice. Is it
I have received the notice. Is it there?
When?
I have sent it this in my mobile, but client today morning only they have provided through WhatsApp from the local adalat. They have sent this going to be held on this coming Saturday.
Yes. Even informed. Yes, as it informed that matters being placed for the National Lok Adalat on 14th. Just after
Lordship.
Yes.
Much blessed, Lordship.
Item number 6.
Please, Your Lordship. Lordship, we are not filing any rejoinder in this matter.
Yes.
Let the matter come up for hearing, Your Lordship.
You file affidavit. You file rejoinder also?
We are not filing, Your Lordship.
You know, filing rejoinder. MS Emma Rahman on behalf of the petitioner submits that no rejoinder will be filed. This is a matter for hearing in the usual courses.
7.
May it please, Your Lordship. Your Lordship, we will require some more time to file rejoinder application.
How many times you've taken?
This is the first time, Your Lordship.
Yes, sir. Mr. Elkoch prays for and allowed further time to file rejoinder. Less thereafter. Yes.
8.
Lord,
we are filing the affidavit today, my lord.
But this is the 5th occasion, my lord, and we are running out of time.
We are filing in the course of the day.
Yes,
What
my lord,
matter
but
about?
in view of the vacations, my lord, in a similar matter, your lordships had directed them to have the review board, my lord. This is also a case where I was subsequently referred to Nigrams and I was found fit. Your lordships kindly have your lordships order in one particular matter. Para 2, my lord.
Yes, Dr. Mosika, what do you have to say in the affidavit?
Well, this case is different, my lord. Well, here, at the time of joining at the training center, my lord, he was a detailed medical examination is done, and there he was found suffering from hypertension in young. And even in the review medical examinations, it was repeated that he is suffering from hypertension, my lord.
They talking about some Negrim's examination?
Yes, Your Lordship.
My lord, that was
Your Lordship's
at his own instance or at
No,
the
no, no.
instance of the respondents?
At the respondent's instance.
You address that in the affidavit?
Yes, my lord.
Then file affidavit. It says Dr. Muhammad submits affidavit file report for the day. List thereafter also for rejoinder if any.
But for a moment, may kindly have page 176, my lord, annexure 9.
Oh, Mr. Let it take its course. You get the affidavit first, so the court can be in the position.
Yes,
to
my lord.
examine.
I just want to point out.
Yes.
Lord, page 176, annexure 9. In the middle of the page, my lord, on the right side.
Referred from ER hospital.
ER hospital.
As a case of HTN in young.
Yes.
Yes.
Item number 9.
Respondents are yet to file their affidavit, my lord.
What's the matter about?
This is regarding, my lord, the extension of the agreement, my lord. An agreement was given, my lord. There was an agreement. A lease was given to them, my lord. Not waived. Yes, it's a non-tribal trading station, my lord, where they are collected.
It's over now, your contract.
Their contract is over. The private respondent contract is over, my lord. On the pretext of COVID, my lord, the extension was given, my lord.
When's the extension till when?
26, my lord.
Have you filed affidavit? Why?
6 weeks has been given to them, my lord.
Link cat and mouse. Then?
By next date we will file, my lord. Even for this day also.
You are running departmentally?
No, my lord. But here what happened, my lord, the check, the non-tribal gate was through a proper tender allotted to a contractor, my lord. Now, there is a power under the agreement to extend that. Now, because of COVID and other intervening circumstances that period of time, the district council took a decision to extend its tenure.
By the executive committee?
By the executive committee.
They don't file affidavit.
My lord, the power of extension was not contemplated in the tender, my lord. Only in the agreement subsequently. Moreover, my lord, prior to this agreement, my lord, there was another lessee, my lord. He has also prayed a similar sort of prayer, my lord, was made. His prayer was not accepted when it was COVID, my lord. Now, my lord, there was an order of this honorable court, my lord, that limestone and boulders cannot be transported, my lord, or exported, my lord. On that pretext, my lord, they have given the extension. Indirectly, they are taking the shelter of this order of this honorable court, my lord.
Regarding?
Regarding a limestone was banned, my lord, that it cannot be exported with a minor mineral license. They have contemplated that, my lord, that because of these situations, extension has to be given. How it can be, my lord?
The extension is granted in December 23. They came to this honorable court in September 24, my lord.
Let them file the affidavit and let there be last chance, my lord.
Yes, Dr. N. Mosika for respondent number 124. 125. And Mr. Jishla for 6 will follow for the 2 weeks' time. Expected on the next date, the affidavit should be on board.
Hello.
Item number 10.
I've just been served with the copy of the affidavit yesterday, so I'll require to file a rejoinder.
It is submitted that the respondents filed affidavit. Mr. P. Nobody prays phones allowed. 2 weeks time to file rejoinder.
11.
Lordship, the respondents have filed the affidavit, Lordship.
They filed?
They filed on 4th December.
You want to file rejoinder?
I'll file my rejoinder.
So please phones allowed 3 weeks time to file rejoinder. Just thereafter.
12.
She thought affidavit rejoinder. They reply thought rejoinder. Last time we thought affidavit. Now affidavit rejoinder. Yes.
May I please, Your Lordship? Your Lordship, in this matter, I am required 2 weeks' time, Your Lordship, to file the affidavit.
When is this matter filed?
13th September.
What's the matter about?
Akang matter, my lord.
I,
Private respondents have been served.
yes, my lord.
I've been
I
sick.
had the appearance, my lord, in October.
Are you filing affidavit?
My lord, I'm praying for another 2 weeks' time because translation is taking a bit of time, my lord.
As prayed 3 weeks for them not the respondents by affidavit. Just after and so on.
13.
Lordship, I'm praying if this matter can be taken at the end of the board, Lordship. This matter will take some time, Lordship.
Where's Mr. Paul?
He's here, Lordship. He's here.
Your Lordship.
At the end of the board, Lordship. I'm
Because
praying.
there are other matters also, even that one matter is listed in Supreme Court, Advin Lingdo, and in item 20 in Justice O Court, that MTATA scam matter, my lord. So I have to argue that matter also online.
So who are we to, the courts left at the mercy of the councils, who are we to accommodate?
This matter, there is nothing remains in the matter, my lord.
Have it on Friday then.
Friday, Lordship.
Monday, Lordship, may have it on Monday.
Due to the personal difficulty of the arguing council, matter stands adjourned to Monday the 16th December.
14.
Lordship, I require a week's time to file my affidavit.
What is the matter about?
Lordship, she's been removed as the head teacher from the school, but she's
There's
still
an interim
continuing.
order, correct?
Yes, yeah.
She's still continuing as a teacher, Lordship.
She's going as a teacher or as a head teacher?
She's continuing as a teacher. She's been removed as a head teacher because of some complaint. She's still continuing the school, Lordship.
There's an interim order?
There's
Yes,
an
sir,
interim
Lordship.
order.
Where is that order? Dated? 27?
27/9,
Okay. Oh, inquiry was done, but nothing is okay. Yes, Mr. Emil Nompur, on behalf of respondents number 1 and 2. 3 to 5 is appearing.
State is not
3 to 5 state.
State is not a necessary party,
1
Lordship.
to 2, where the main contesting respondents praise for and allowed for to kind of file affidavits. Now, Mr. Kivarach, on behalf of 3 to 5 says, since they are just a formal party, no affidavit forthcoming from these respondents. Yes. Yes, also.
Interim order may be continued, Lordship.
Interim order will continue until further orders. Yes.
15.
Yes.
In this matter, the state is yet to file the affidavit, Lordship.
We've received the instructions, my lord. We'll pray for some time.
When do you receive instructions?
My lord, recently, my lord, we received.
Recently means date?
My lord, one we received on 20th November, my lord.
20th November?
Yes.
And the other one?
The other one on 25th 11, my lord.
What's the matter about?
My lord, this is, they are claiming certain benefits, my lord.
They are teachers?
My lord, they are employees.
For regularization, Your Lordship.
Okay, Mr. Kivarach, please for around further to identify affidavit is.
Come after vacation, my lord.
16.
So they have to come after vacation.
Always.
May I please, Your Lordship? Your Lordship, in this case, we have filed an application for impleading the Rajendra Tiwari, Your Lordship, as necessary party.
Who is this?
He's the accused against my complaint, Your Lordship. In this case, Your Lordship, we filed
Where's
this.
the impleadment petition?
It's in. We filed.
Oh, is that case? I thought it was that litigation case.
I pray that notice may be issued to him, Your Lordship.
Is that been pleaded as yet?
Not yet.
I pray that
Do
he
you
may
have any
be.
objections?
I have noticed. It may be implemented when notice will be issued.
Take down this case 197/2024. This is an application for impleadment of one Sri Rajendra Trivedi as respondent number 7 in the main writ petition. Stop. As per MSR Karshi submits that the respondent, the said person sought to implead is necessary party for adjudication of the writ petition. Stop. Next part, the same not objected to, but Musica. Accordingly, stop. Accordingly, next paragraph. Sri Rajendra Trivedi. And the number 5, para number 5 is hereby impleaded as part number 7. Next paragraph, registry to necessary corrections in the main cause title. And in the main case, in view of the order passed in this case number 197, petition to steps for issuance of notice on the newly impleaded one number 7 within 3 days. Yes, that after and so on.
Hello, Impleading.
Yes.
17.
Yes, my lord. My lord, I'd like to refer to the incident that happened on the 16th November. It's in my miss case 205 of 2024.
Miss case or affidavit?
It's a miss case, my lord.
Why?
Because, my lord, I needed certain directions, my lord. I had.
You received copy of this, Dr. Mojika?
My lord, I have received copy. In fact, I have received instructions just last night, my lord. So, lordship permits me with 3 days time.
Case number 205/2024, NLPC 387.
My lord, if we'd go to
One
page.
second.
Yes.
This is an application by the petitioner for with a prayer.
My lord, my prayers
to
at page.
address for certain directions to issue to the respondent school. Mr. Raghuza submits that he has just received instructions. This is the matter on Monday. Yes.
But my lord, may I please?
Monday. We got a long list today. Monday. Yes.
Respond number 3, my lord, as per the direction of the Honorable Court, we have to file the report.
If I will see on Monday, yes. You will give instructions on that miss case.
Yes, my lord.
18.
Please, Your Lordship, steps already been taken for 7 and 8. The delivery status is also here. I have it.
Yes.
It's been delivered on the 2nd. I can bring this on. Status report. And this is regarding the where the respondent number 8 had submitted false and misleading information, that is with regard to his marital status in the concerned respondent authority, and he got retirement. So the information is false, so I've challenged that.
Where's the miss case?
Miss case here.
Yes, Dr. Mojika.
But I'm yet to receive instructions for this matter.
Commissioner Roy.
Yes.
It's been submitted by the learned counsel of petitioners that the respondent 7-8 has since been served. So, proof of delivery of service of notices has been produced. A proof of delivery of service notice from the postal authorities is produced. Stop. We can file by affidavit.
Yes.
The same to be filed by your affidavit. Stop. Dr. Enmoska, how much time do you need?
Immediately after election, I'll file it. 3 weeks time.
3 weeks time is allowed for affidavit. What about the miss case?
Meantime, miss case. Just
what are you asking on the miss case?
Direct the respondent authority not to release the or disburse the pension benefit to the respondent number 8.
But
Pending disposal of the writ petition.
Well, there are 2 aspects, my lord. Because
now holiday
I'm not aware, my lord, whether it has already been dispersed or not. That's the first part, my lord. And second part, they are referring to one divorce order passed by this honorable court, my lord, and that order was ex parte. Now, whether the respondent number 7 is aware about this or not.
Number 7, State Bank.
Yes.
No,
Lordship, if I may please, Your Lordship, come
State Bank.
page number 12 of my writ petition. This is the approval of the voluntary retirement pension in respect of the in respect of the petitioner, or in respect of the respondent number 8, Your Lordship. Come to page 12, Your Lordship. Alexia, 1.
That is since July, my lord.
Page 12. Now the next page 13, Your Lordship. You'd see
Now
the
you're
column.
retired 1st November forenoon.
Yes, 1st November.
Yeah,
Got
okay.
retirement 1st November, but his benefits are not been released to him. He has not received as yet.
How are you sure about that?
I've got that information from the petitioner. She had confirmed that. It takes some time, at least 2 to 3 months, to release those benefits.
Interim order may not be necessary, my lord. We'll
It
file
is
affidavit.
necessary, Your Lordship, because
It can be
the
restored.
vacation are coming, and at any point of time may be released, and I may suffer.
Yes,
Considering the fact the notice has already been
for
served.
Miss case number 202 or 2024. This is an application. Dismisses application will file bring for directions to issue the respondent authority not to release or disburse the pension benefits to respondent number 8 pending disposal petition. Is submitted by the Senate Council that the petitioner, you're the legally wedded wife.
Yes, yes, sure.
Who stated to be the legally wedded wife of respondent number 8. No, sorry.
And only one thing, I will just interrupt. Here, what happened, my lord, is she's the first wife. Divorce was granted, my lord.
Ex parte.
But divorce may not be ex parte, my lord. Then what happened? She filed an appeal, and the divorce granted was set aside by this honorable court, and that order was ex parte. Now here the question of pension, because the person is still alive, my lord.
Pension will go to him either ways.
He'll go to him, my lord. No, not to wife. The question of
also
wife.
It'll go to him either ways, yes.
What here, the rate here?
We asking for maintenance.
Maintenance is also.
Right.
Lordship, it's very important. Lordship, the thing is, I did not press the first instance, Lordship. Now, since considering the fact.
You're saying the first instance his anxiety is only that, like, she'll be cut off. Like, at least some directions be issues that her maintenance is being paid. You're seeing maintenance, right?
No, as of now, no.
Then
it's still pending, Lordship. I came to know that he had submitted wrong information.
That's different.
When there's an assets and liability submitted, at least till the next date, Lordship.
That respondent number 8 stated to be legally wedded wife is before this court in the connected writ petition.
This case, at least the next date, Lordship, please.
Yes, as the respondent number 8 had submitted false information to the authorities with regard to his marital status.
Yes.
As a matter deserves further consideration, the miss case is closed and the main appropriate petition will be taken up for consideration. No point in the miss case.
Yes.
This case is disposed of. After the list, after 3 weeks, affidavit, the other one.
19.
What's the situation now with those 13 seats?
My lord, there are two matters, 19 and 28. So far as 19 is concerned, my lord, in 19, the case of the petitioner is that she was not allowed admission against the management quota.
Right.
And the management has said that she did not turn up for admission in management quota. That is the case of the factual dispute between. Now, case of the state is, my lord, that management quota admission was not correct. It was meant for a state quota, and therefore the students against state quota have been admitted. So as on today, there is no management quota according to the state, my lord. There is no management quota, and the college has also admitted the students from state quota. 13 students
Yes.
So then, therefore, as on today,
No, I'm more concerned about the court's more concerned about the what happened to that the other 13 students,
students
who
that
have been admitted
they-
over and above
the state quota. State
No, no, not state quota. Forget state quota. Okay,
Yes.
where the state quota?
Subsequent.
The subsequent petition. Where's that?
Lordship,
Where
item
13 people have been.
I am appearing in cell number 20.
Yes. What has happened? Where's the college?
they have been provisionally admitted also, Lordship. As of today, 163 students are
Yes. What is the
attending
position
classes.
now? Are you increasing the number of seats?
That would need the approval of the
All are continuing. Then what is how are you going to resolve the matter? How the college will resolve the matter?
Your Lordship, in fact, I want to receive some more instruction. We have received a copy only yesterday. We saw the copy only yesterday. I am yet to receive the affidavit.
Mr. Khan standing behind you, he looks to be full of instructions. Yes.
Only yesterday we have got the copies of the
Copies of what? Of the writ petition? Is that correct?
Yes.
Why you served it so late?
Order was part of Friday, so it's on Monday.
Oh, you sent by post. They will have it on Friday, no matter. We will close it yes, on Friday.
Tuesday, Lordship, ma'am. Friday, I'm in some difficulty. Monday or Tuesday, whatever is convenient.
16th. Yes, as the senior counsel for respondent number.
In that case, 1996 and 7.
In item number 19.6 and 7, in the other item 6 and 7, as there is a senior counsel for 6 and 7 submits that the writ petition, copies of petition have just been received. This is matter on 16th for further orders. We'll dispose it of on 16th. If you let them continue, then the whole matter gets over, and I don't think the writ petitioner here will have any grouse after that.
Lordship, if the
Subject
management,
what you're saying.
Lordship, if the management students are on board, then I definitely have a case, Your Lordship.
Okay, yes.
Obliged.
20 tomorrow may kindly be continued.
Tomorrow?
Tomorrow.
Tomorrow, yes. 20 yes.
Obliged.
Hearing 24.
I thought it'll take some time. Yes,
yes, Lordship, this is the we have the matter have already part heard, Your Lordship. This is the matter pertaining to the course of doctrine, which Your Lordship at the very first instance.
Oh,
yes, ma'am.
Yes, Lordship.
We have got the rules.
You got the right rules?
Yes, ma'am.
What are the right rules? The correct rules, not rather.
All right. Yeah.
You are aware of this?
Yes, Lordship, I'm aware.
That now they are governed by the Meghalaya Directorate, Daftari Jamadar, etc., Grade 4 Service Rules, 1994.
I'm aware of that, Lordship.
Yes, how do you meet that their contention? The 9, Rule 6.1.
Basically, this Duffy post is a promotional post.
Yes. Is the pay scale the same?
No, Your Lordship, it's not the same.
It's a promotion, it's a grade 3.
Lordship, if you,
Yes.
you may kindly
Yes.
have page 34 of my petition.
Yes.
This is the letter dated 27 June 2023, whereby the respondent number 7 has issued me this letter that there has been error in the part of the respondent 7, and she issued me this letter that I will be appointed as to the post of Daftari with the pay scale of 19,000 to 44,800.
Yes. Are you employed at all now there or no?
Yes, I'm employed.
You're working as a?
Lab bearer.
Okay, lab bearer is a grade 4 post.
Yes, Lordship.
Okay, since the rules provide that, then your case is over.
That's all.
But Your Lordship,
This
I will
not have any meaning because
I will
this
not
is
challenge the rule, Your Lordship. However, my small prayer is that since it is the error made on the part of the respondent 7, so
who's respondent number 7? You're respondent number 7.
Private respondent.
The school?
The school.
Seven. I'm
Since this is the era of the respondent number 7, then your lordship kindly direct them to pay me the
No.
skill pay, the CM skill pay. Then how can I be suffer since 2017, your lordship? And even all documents which has been in
No,
record.
when were you given a document for 23? When did you file his petition?
23, your lordship.
23.
Then
He was appointed
now you're
in
getting the
17,
pay
after
scale of
6
the
years.
lab bearer only.
Yes, lab bearer only.
After 6 years, he has come. After 6 years. Ever since he was appointed as a lab bearer. What prevented him?
But your lordship, during
he has
that
come
point
after
of time,
6 years.
I have approached the respondent to make some.
And
you
if there,
appointed in 17.
Madam.
Yes. So, then where's the order of reversion after the order of the private respondent? 27 June 2023. After that, where's the other whereby he's been restored to lab bearer? Where's that order?
No, your lordship. Since the my appointment, I has been appointed as lab bearer. You may kindly have.
No. This letter, see, 27 June 2023, lecture 10.
Yes. Or since then it's just a letter, your lordship. But after
You continuous lab bearer only?
Yes.
Now he's continuous. Okay.
Yes, heard Mr. Khanong Backland Counsel for the petitioner. Stop. The writ petitioner has sealed the has no, not as the writ petitioners agree with his non-appointment as Daftari, for which he had qualified in the selection conducted by the district selection committee. Correct?
Yes, your lordship.
Yes. Yes, on 13 July. No, on. You were recommended when by the DSC?
Pardon, your lordship.
When were you recommended by the district selection committee? 6 October 17.
Yes, your lordship.
No. Which is yes. So, on 6 October 2017. Stop. It appears that on his selection, on the recommendation for the post of grade 4, the petitioner was appointed as a lab bearer in the respondent number 7 school by an order dated 23 December 17 and has continued as such. Stop. Next paragraph. Mr. Khanong Wagner, counsel for the petitioner, has submitted that though the petitioner was selected to the post of Daftari, which is a grade 3 post, he was appointed lab bearer, and this was corrected by the respondent number 7 via a letter dated 27 June 2023, whereby he was given an appointment as Daftari in the scale of rupees 19,000-44,800 with immediate effect. He submits, however, this order of dismissal was never acted upon, and till date has continued as a lab bearer. He prays, therefore, that appropriate order be issued directing the respondents to accommodate him against the post of Daftari and be paid a higher scale than what he is enjoying now. Stop. Mr. A. Khan, on behalf of the respondents number
3 and 7.
3 and 7, had initially submitted that the post of Daftari was a promotional post from grade 4 peons, and in this context had relied upon the Meghalaya within bracket civil secretariat, then within bracket record supplier, comma, Daftari, comma, Jamatar, etc., and other grade 4 staff, close bracket service rules 1986 to in support of this case.
94, brother.
94, sorry.
Rule 6.
No, 86, the other rule. I'm talking to the early rule.
Brother.
Is had initially had relied upon. Okay, so and so. Yes, sir. Stop on inquiry from the court that the rules. Inquiry from the court as to the applicability of said rules as the same referred to the Meghalaya Civil Secretariat. Mr. A. Khan then sought clarification and has today produced the rules as applicable to the service of the petitioner, which is petitioner in the school, which is titled as the Meghalaya Directorate, capital D bracket Daftari, comma, Jamatar, etc., and grade 4 service rule 1994, and submits that rule 6.1 and the small 1.6.1 PI provides that the method of recruitment to the post of Daftari is by appointment to the post method of recruitment to the post of Daftari is by promotion from amongst literate peons in the respective directorates possessing the required qualification. He therefore submits that the selection of the DSC being an aberration, his appointment, however, being to a correct post, no interference is called for by this court. What do you have to say?
Lordship, I'm the senior most for the respondent number 5.
Oh, you're the private respondent. Yes. You've been promoted.
Yes, Lordship.
Mr.
Nicholas
Salingdo, appearing for the respondent number 5.
Lordship, the gradation list is at page number 17.
5. Yes, sir, for 5. Submits that he, being the senior most from among the peons, had vested right to occupy the post of Daftari as per the relevant rules. Next paragraph. Having heard and counsel for the parties and having considered materials to record, it appears that the selection of the DSC as is evident from where the SDSC as is evident from the letter dated 28/11/2017 with regard to the recommendation. The same was a qualified candidate for the post of grade 4, and as such informed grade 4 stop. However, as Daftari post is not a grade 4 post, it appears that the petitioner was accordingly appointed as a lab bearer, which is a grade 4 post. Stop. The nomenclature given selection, therefore, being an aberration and an error committed on the part of the DSC, which had conducted the selection for the grade 4 post. No right vested on the petitioner to claim the higher grade 3 post stopped. Furthermore, it is seen that Rule 6 so, which has categorically provided for a method of recruitment of post of F3 stopped. For the sake of convenience, Section 6 also is reproduced herein of the so rules is reproduced herein below stop. Accordingly, in paragraph for the reasons aforementioned, no case was made out for any interference, and the writ petition stands dismissed.
27.
Yes. Yes, Mr. Manta.
Yes, maybe, please. This is the petition where the judgment passed by, then Honorable Justice Baipai, a deadlock has been created. MST means 50% has been released to the widow, under 50% is remaining. And the drawback here, if your lordship is pleased to turn to page 92 is the order, 3/5/2024. The tribunal has expressed the inability to release the remaining 50%. Your lordship.
One second. Page?
Page 92 is the order, 3/5/2024.
92.
Yes, page 92. Lordship got that?
3/5/24.
Yes. So, second page, the reverse side, your lordship will see. There is a copy of the judgment dated 10th August 2019 passed by the Honorable Guwahati High Court Ceylon bench, wherein at para 8 it is observed on the appearance, this is the problem, on the appearance to the owner, the insurance shall deposit a balance amount, which shall then be released by the tribunal to the claimant after the owner furnishes security to the satisfaction of the tribunal. After the owner furnishes a security, but they have deposited, owner appeared, she is a widow, she appeared, then they have deposited remaining amount.
The owner?
Owner.
Yeah,
Not owner deposited, the insurance,
yes.
they deposited remaining 50%. But the owner, she is a pauper, she gave an application for insolvency, nothing is left, even the truck has been sold, nothing is left, and late LD Choudhury appeared on behalf of the owner, given the insolvency, but the tribunal has rejected the place and is still hanging on for that repayment. Then the tribunal has expressed this difficulties. The last phrase, in view of the direction of the Honorable High Court, as stated above, this tribunal is bounded by the said direction and hence is unable to release the amount as prayed until the owner furnishes the security. So that motivation is I bring for you.
What is this 14.6?
14.6, they have taken, the trial court has tried to bring the owner back again, but failed, Your Lordship. On 14,
when did the owner appear and file as an indigent?
Insolvency petition. It is there, Your Lordship.
Okay, let's come for the direction of this court. Page.
The direction of this Honorable Court. Your Lordship can turn to page 66. Actually, the judgment starts from Your Lordship, page 53 by this Honorable High Court in MSc Appeal 6 SH of 2008. Page 53 is the starting of the judgment. And relevant page is 66. Page 66, paragraph
Order
8.
is 10th August 2009.
Yes. This is the oldest case, Your Lordship.
But what 2019 referred to by the...
Yes.
No, referred to by the...
No, 19 also because there were some order passed, not by the High Court.
No, see.
Yes, yes.
Where you read just now, page 92,
yes, yes. That is actually, it is 9, not, it should be...
Was a mistype.
Yes, there's a mistake in the order. Honorable, here is a copy of the judgment of 10th August 2019, they wrote.
Okay, where were you reading from this order?
That is 10 August 2009.
Yes, where are you reading from?
I want to read paragraph 8, page 66. Page 89,
Para 8, page 89.
89. High Court
Para 8.
Para 8 of page 89.
But this is
89 of my petition.
You reproduce it twice in this petition. Yes. Why? The first is at page 53, same order, correct?
No. That Silomans, yes. They have given again twice. Anyway, I'm sorry.
Why given twice?
By mistake has given.
Strengthen your case.
By mistake given. Page 66, sorry.
Reinforced.
Yes. By mistake. Page 66.
Page
66. The justice bypass judgment, Your Lordship.
Okay, page 66, yes.
Para 8, Your Lordship.
Yes.
The obstacle of the foregoing discussion is that this appeal will stand disposed of as indicated hereunder. The appellant insurer is therefore directed to pay 50% of the awarded amount, together with the interest payable in terms of his judgment, to the claimant respondent within a period of 2 months from today. Any amount already deposited or paid to the claimant shall be deducted accordingly. The tribunal shall thereafter summon the owner of the vehicle, and if necessary, may also employ a coercive measure including seizure of the truck to ensure his attendance before it. If necessary arises, the executing court may take assistance of the transport authority. On the appearance of the owner, the insurer shall deposit a balance amount which shall be released by the tribunal to the claimant after owner furnishes security to the satisfaction of the tribunal.
Okay.
This is the only hint of the problem.
Unless the owners furnish the security,
there's balance amount cannot be released.
Yes.
Therefore, it creates a deadlock, Your Lordship. In fact, as per under the social welfare legislation, this MSCT, all these cases, Your Lordship, we need not be made to suffer.
Yes, Mr. General. You have any objection to the...
I think in the trial court, he was saying if the High Court modified that, I have no objection. And in fact, Your Lordship, before
I have to go by client's instructions. So I had, Lordship may kindly recall, I had sought specific instructions whether this prayer.
What is the amount?
Amount is hardly, I think.
The total amount was 9 lakh something.
9 lakh something,
so
50%
is? It's about 4.5 lakhs.
That's right.
That's all deposited when?
That was deposited immediately after the High Court order, 2009.
It's still lying like that now?
It's still lying like that.
Without interest.
Is it in interest bearing account?
The MSCT's account, but the interest will go to the MSCT, not to the claimant.
Yes.
So, my lord, I had sought specific instructions. Unfortunately, my lord, my instructions were because the amount is a fairly substantial amount, and there is and the owner is missing in action, my lord. So, my instruction was that we cannot really concede. So, under instructions, my lord, I have to say this: I'm constrained to raise 2 objections, my lord, against this petition. My first point, my lord, would be the nature of the petition. If Lordship kindly looks at the first page.
Technical objections.
Yes.
On law or technical objections?
On law. It's the petition, my lord, has been cast as a revision petition.
Yes.
Now, and the order under challenge, my lord, is the order which my senior just read. That is the 3rd May 2024 order. So, my lord, the contours, the scope of revision is very well defined, my lord. The only thing that this honorable court has to see under 227 is whether there is any procedural irregularity with the impugned order, my lord. Now, impugned order, very clearly, my lord, there is no procedural irregularity. MSCT has expressed a difficulty in view of the Honorable High Court's 2009 order.
Yes.
So, that being the case, my lord, my submission would be backed up by the law, if Lordship allows me to place it, would be that 227 would not be maintained, my lord.
Yes.
Having said that, my lord, my second point would be that the prayer may be looked at of the petition. That is at page 10.
Page 10.
10.
Yes.
Under the premises and circumstances stated above, it is humbly prayed that your lordships would be pleased to admit this petition and call for the records of MST so and so.
So you're seeking a review?
Yes, ma'am. So it amounts to a review petition. Now, even for a review, my lord, again, I have to place the law, my lord.
It is a review. It has to file a review. There have been cases here they filed review after 10 years or so.
So I'm not on the point of condemnation because that is also a point of delay. Delay is it's a substantial delay, but I'm not really pressing that point. But on the point on the ground on the issue that it's a review petition, Lordship
No, I
McKinley-
think it's a review petition because see this is observation of the court that he is not the petition is not aggrieved with any order.
True, my lord.
So circumstances have changed. That has they have not been given the benefit of that balance amount of the compensation. That's all.
Yes, madam.
So the remedy, that's what they see with 227 for correction. But correction is for
for deletion or modification of a certain direction previously passed by this honorable court. Now it amounts to a review, my lord. My humble submission would be it amounts to a review. Page 6 of the compilation, if Lordship kindly looks at.
Thing is, see that this lady also is, how old is she? The petitioner.
She's an oldest citizen. Oldest citizen.
Yes, Mr. Jindal.
Yes, my lord. Page 6, my lord.
Yes.
So
latest judgment.
Latest from May. If Lordship looks at page 8, para 20.2.
Yes.
When the review will not be maintainable, I'll skip 1, 2, 3, 4. Point number 5, my lord. A review is by no means an appeal in disguise, whereby an erroneous decision is reheard and corrected, but lies only for patent error. 6. The mere possibility of two views on the subject cannot be a ground for review. So, my lord, the contours and the limitations and the scope of review is also very well defined. So, my lord, I would humbly point out, with respect, that what we are left with, my lord, is that this petition is invoking mercy, my lord, from this honorable court, because neither 227 would come to the aid of the petitioner, neither review jurisdiction would come to the aid of the petitioner. So, whether this would be a fit case to extend Lordship's hand of mercy, my lord, I leave it up to Lordship.
What is 226?
I hold my submissions on that, my lord.
Also, two choices come into play. There's a reason because appeal gun, review gun.
No. The review, even see, there are certain grounds for review also. The thing is that you're asking for review on circumstances that change and new. That's the only thing. And when this surfaced in the last order of the MACT, that's the thing.
Yes.
I'm not sitting at advisory jurisdiction, but then, I think just style your petition differently than court consider, because this is a case that should be given consideration. But 227.
But of course, off the record, your lordship, the learned counsel, senior counsel, Mr. Sisi Doctor, he's from the head office. He directed them to release, not to make the widow suffer. His opinion is there. He told me to address the court, and he has given the opinion to release. I don't understand why Mr. Jindal is coming with this point.
That you can settle him outside the court.
Yes, outside.
That is privileged. That is privileged communication.
I cannot go on instruction from the head counsel and the.
No, I understand. I agree. Therefore, I said off the court. Off the court. So, but your lordship, these are the social welfare legislation.
Fine, but then you come in a
no, because the reason is that Ali Chaudhary was repenting, learned senior counsel.
No.
He also died. Then
you are the person who should seek review. That's all.
Oh,
that the judgment be reviewed to the extent only.
That time has gone. But now it's a deadlock. Therefore,
what deadlock, Mr. Manta?
Because in fact, we were with the hope that the counsel the owner will come and give an undertaking, but says unable to give the undertaking. Then
What
how?
is the insolvency petition? What orders were passed?
Petition, yes. I've given the
page 68.
Page 60?
68.
68. What orders were passed here?
It was dismissed for default, my lord.
Dismissed for default.
Oh, there's no declaration also. I thought there was a declaration as to insolvency.
Dismissed for.
In fact, my lord, this is an honest petition because if Lordship sees the bottom, it's been filed under Section 6 of the Provincial Insolvency Act. This was filed in 2017. Provincial Insolvency Act, my lord, was repealed in 2016 by IBC, Insolvency and Bankruptcy Code. So they filed a petition
Which section 10(1)(a) of the Provincial Insolvency Act 1920. Praying for that was
which was repealed the previous year.
And it was dismissed for default.
It was then dismissed for default.
Where's this owner from Punjab?
Punjab.
Chandigarh. Learned Court tried so many years to bring, but could not get it thereafter.
Yes. Are you sure they just filed this to avoid liability?
No, what the letter judge told me that.
I mean, we're just going on hearsay now.
No, means, that of course, I cannot say on behalf of that. But the deadlock has been created by the judgment. That's the problem.
She has no property.
Nothing is there.
So what should we do?
I think if that can be allowed to be released and let the insurance go ahead with the owner.
Yes.
It's not that the insurance doesn't want to pay.
If I can make
they have deposited the money.
If I can make a off-the-record suggestion, a very humble suggestion, my lord, subject to what senior says. If my lord can record in today's order that my lordship has examined the records and lordship is directing or expecting the insurance company to have a relook at the matter, maybe that might force them to have a change of heart, because I'm bound by instructions.
The court on the impression that insolvency proceedings had concluded, and the whoever the owners declared insolvent. So then it simplifies whole process that that there's no question of them ever satisfying or be able to furnish security. Then the insurer will release the money. Sans the security given by the, but then that also is just ended like that.
Therefore, it amounts to a deadlock.
That's why the court, the order of this court, still has some force that you're going to cause the appearance of the owner by using coercive methods also, by using so that is the thing. So that means coercive methods means the court can even order for warrant of arrest to be issued. I mean the tribunal itself.
Those has been done. Day after day appeared. Owner appeared. And owner said that can't even pay, nothing is
can't
there.
even pay, but then this is inconclusive, the proceedings.
Inconclusive.
Anyone can come, can say,
yes,
I have not been, I can't pay.
So, by submission, Your Honor can allow to release the money, let insurance take up.
By this application of 227, stop the petitioner is seeking a modification, rectification, and alteration of a judgment and order dated 10/8/2009 passed by this court, passed by the early jurisdictional High Court in it was MAC. Was it
MAC appeal number 6H,
6H of 2008.
In MAC appeal number
6H.
SH of 2008.
SH of 2008. Stop. Next para. It is submitted by Mr. S. P. Matrimonial Senior Counsel that this prayer is sought in view of the fact that the order, the said order dated 10/8/2009 had at para 8 directed that the tribunal was to summon the owner of the vehicle, who would then no Thomas due to the fact that the tribunal, by order dated with that 3/5/2024, while considering the matter of release of the balance amount, which has been deposited by the insurance company as compensation, could not be released in view of the operational directions contained at para 8 thereof of the judgment dated 10/8/2009, wherein it was stipulated that on the appearance of the owner, the insurer was to deposit the balance amount, which was then to be released by the tribunal to the claimant after the said owner furnished security to the satisfaction of the tribunal. It is further submitted that the owner had appeared before the tribunal, but however was not in the position to furnish the security as directed due to unavailability of due to financial condition, which he submits the owner had also filed an application before the court below for declaration of insolvency. It is further submitted by the counsel that the instant petition, the petitioner was compelled to file instant petition as a mercy petition in view of advancing age, and for directions that the balance amount be released to the petitioner, sans the requirement as directed in the order dated 10/8/2009. Accordingly praised that some latitude be given and that the order 10/8/2009 be altered to recall this requirement, and consequently to direct the respondent insurance company to release the amount to the petitioner or claimant. Next paragraph. Ms. S. Jindal, Learned Counsel for the respondent number.
Sole respondent.
For the sole respondent, right here.
Sole respondent.
For
for number 1.
So for number 1.
Number 1.
You could not serve number 2, correct?
Could not found.
Because you went wrong address, 80 Road.
No, that is the only address available in the records of the.
Yes, forget it. Mr. S. Jindal, appearing for respondent number 1, however, has raised a few objections as to the maintainability of the petition in its present form, and submits that an application under Article 227 will not be is not the will not be assistance to the petitioner, as there is no error in any order that has been sought to be corrected, and that too it's for exercise of powers of supervisory jurisdiction and not for alteration or modification of orders passed by this court itself. You have not made a submission, but I'm making it for you.
Obliged. That
Because
should have been.
the basic is supervisory jurisdiction.
Yes.
It is not for
Correction
for
of errors.
review of orders of concurrent
My lord,
benches.
my lord.
And if that is the case, then you'll file application to do several correction of order of my other brother judges.
I cannot.
Will that be material?
No, it can't. It can't. I should have better worded my submission.
Yes. Stop. He further submits that no, I'm done. Will be of no assistance to the petitioner. There is no error in the order of the tribunal, and what is sought is for a correction of an order of this court itself for alteration, which is not permissible in law. Next paragraph. Considering the submissions and the situation of the case wherein the same amounts of mercy petition by old widow without burdening the parties with the technicalities of law, perhaps the respondent number one may look at the matter afresh to somehow facilitate the release of the balance compensation amount to the petitioner stroke claimant. This is the matter of the vacations. It's expected that on the next date the respondent will come forth with specific instructions. Yes. Sorry, Mr. Because 227 won't come.
28.
This is the only supervisory power left.
No. Supervisory power of whom? I can't. You're not asking supervisory power of what? I can't supervise a concurrent bench. How will I supervise concurrent bench? As in correction of the alteration, it has to be a review.
That's right.
How will I correct? How does court correct an order of, part of someone else? That's the thing.
Difficult, very difficult situation.
Not difficult. It's very simple, but you're not seeing it. If I was a counsel, it would have been different. Yes.
28.
Yes.
At least if the insurance company be a little rebel.
Yes, without burdening with technicalities. But I just give an order, yes.
Obviously.
Yes.
Well, I was directed to produce the extension order of the present private respondent who is not appearing. So, present private respondent who is not appearing, my lord, in this matter.
Extension order meaning?
The Gura, my lord. His term has been extended again on 16 July 2024. And this will go to for 18/7/2025 till 18/7/2025.
We have filed this petition against the order dated 22/12/22 passed by the executive officer at JHDC, and also quashing the extension orders. They have filed the extension order. I was the original Gura, but I was illegally removed from my position, apparently on the basis of judgment passed in WPC number 476 of 22 by this court. But no such judgment was passed by this court, Lordship.
You're Azizur Rahman?
No, I'm
Manan Sakar.
I'm the petitioner.
Who's Azizur Rahman?
He's the respondent number 4, who is the current Gura. He has been illegally appointed, Lordship.
Where's the spot inquiry report? Just show the extension order. It's for each piece Mandalpara, Jurapara, Nayapara.
Yes, yes.
You claim to be headman of which?
It appears, my
Initially,
lord.
I was the headman of Mandalpara, Jwalpara, Nayapara, Bagacha, Patlipara, Silkanan, Tasildapara.
You are headman of those places.
I was the headman of 8
They
villages.
bifurcated it, or what happened?
They have bifurcated, my
Yeah.
lord.
Then?
Now only he was the headman for three village, my lord, which has been reflected in the extension order. So he is challenging this order, my lord.
Now you are still headman for other villages.
No, I'm not headman of any of those villages anymore. So my prayer is that I may be reinstated. Because I was illegally removed, Lordship. Apparently on the basis of judgment in WPC 476 of 22.
Yes, it's just that to relook, see the judgment doesn't say anything about appointing him.
Exactly, Lordship. No such judgment was passed.
Yes.
Even the spot inquiries were held with 70 to 80 people in their presence, and whereas the almost 1500 people are there in that area. No notice was also issued to me.
See the order, Mr. Day.
My lord, I can understand, my lord. I'm in a very tight situation in this matter, my lord. I have nothing to say much, my lord. And it is off the record that I have nothing to say much. But, my lord, what can be done, my lord? This orders, off the record, my lord, this orders has to go, my lord. And, my lord, liberty may be given to us if in case there is a complaint, genuine complaint, my lord, we will address that complaint, my lord, of any person.
(256) Section 12 is what?
256 is the petition that we have filed against the spot inquiry that was earlier conducted. And when there was a new cause of action, we have withdrawn that and filed this current petition.
Okay. You file affidavit? No.
I filed an affidavit, my lord. We have seen, my lord.
Where is the spot inquiry? But then this matter goes to the Board of Revenue, correct?
If in case an appeal will be filed, my lord, but here it is
no order is passed.
No order has been passed, and moreover, it is the EC who has decided, my lord. It's not the EM's order. Only liberty may be given, my lord, if in case there is any complaint against the petitioner, my lord, then we have to address, my lord, that complaint.
Take down. Manan Sarkar. Which village? This is West Garden, Southwest Garden.
Southwest Garden.
The petitioner being aggrieved with his removal as Gura of I have two villages of so and so. Is the petitioner of so and so villages wide. You removed since 22. Since 22 you've been removed.
Yes, 22/12/2022.
So since 22 you've been out of office.
I've been out of us. I've been trying to obtain the certified copies, but
Yes, sir. Being
I was
agree with uh, his removal. I thought we could his removal from the village. Huh? Stop had which which it is alleged was without any reason had preferred representation for redressal of the grievances and also for a copy of the Impleading order 2212/2022, which however was not acceded to by the respondent GHADC. Stop. You don't have a certified copy. No, Tom, no, Tom, sorry, you got the copy later on, yes. Yes, had filed a representation which was not addressed, and as such has approached this court by the instant petition. So, your name?
the petitioner's name.
Your name?
Devapratim Dev.
The Legal Counsel for the petitioner has submitted that the petitioner has no information about any complaints or any spot inquiry that was conducted personal complaints, but only that the respondent number 4 has been appointed as the Gura bride. Where's the order of first appointment of that Azizur Rahman?
Page 43, my lord. Type copy.
Provide an order dated
22nd December.
22nd December 22, which is continuing till date. Stop. It is the Senate Council then has drawn the attention of this court to an order passed in WPC. Where's that page?
It's in page 40 to 41.
This is the order. Drawn attention of this
Annexure
court.
9.
Drawn attention to 476 of 2022, dated 2/12/2022, which had been filed by the parallel respondent, wherein this court, while disposing of the writ petition, had allowed the respondents to look into matter and dispose of the representation of the petitioner therein within a period of 4 months from the date of representation, within 4 months thereafter. It submits that though there were no directions issued by this court for appointment of the respondent number, prior respondent stop. The respondent GHADC had acted illegally in appointing the said respondent by referring to the order dated 2/12/2022, which did not contain any such directions. He therefore submits that the respondent, having acted illegally and arbitrarily, the prior respondent is liable to be discontinued from the post he is holding. So, next, Ms. SD appearing for the respondents number 1, 2, 3, 1, 2, and 3. has submitted that the respondent, private respondent, is still continuing office with its last extension dated, last extension allowed on 19 July 2024, which will be effective till 18/7/2025. He submits that perhaps there was some bifurcation in the villages, which has resulted in the realignment and the appointment of the private respondent. However, he submits that with regard to the reliance of the respondent 3 on order of this court to make the appointment, he has no submissions to make. You have to record that, yes. So we are appearing for the private respondent. Oh, yes. Yes.
Only, my lord, may I add on my submission?
No, we'll give, yes. He however
Only the
praised
ba-
that he praised that the respondent be allowed to rectify the situation and to take corrective measures, but yes, as necessary. Yeah. Make it general, yes. The next paragraph. The heard learned counsels for the party stop. It is noted that though the affirmative service you filed, right? Though the private respondent has been, he was served.
Notice was served to him.
Yes, though the respondent before, private respondent before, had been served notice as far back as on 22/4/2024. No appearance has been made on his behalf. Stop. I thought it's noted. Noted since when? I thought no. Yes, an affidavit indicating service in this regard has also been filed by the petitioner. Stop. Next paragraph. Coming to the coming to the fact of the case in question, this court also cannot come back to the question. The dispute, it seems, is with the dispute initially was with the not initially is with a spot inquiry that had been gone into by the respondent, for which no report or no further instructions, no report has ever been produced before the court. Stop. Further, it is seen that the appointment of the private respondent before was allegedly made by placing reliance on the
order
appointment
dated
of
order dated 2/12/2000.
the order of appointment of the private respondent dated
2/12.
Yes, 2/12/2022. Comma. Purportedly was made purportedly in pursuance to the orders of this court dated 2/12/22, passed in WPC number 476 of 2022. A perusal of the order dated 2/12/2022 nowhere reflects that any such direction is contained therein. This fact, which is present in the face of the court itself, has made the impleading order unsustainable, and without further deliberating on the matter, the same is liable to be interfered with by this court. So, though this court by the order had allowed the respondents to examine the same, as it is noted in the order that the same emanated from a spot inquiry. Nothing has been placed for the court to show that such exercise had been undertaken. The conduct, therefore, of the respondent is highly deprecated and amounts to a misrepresentation of the orders of this court. Next paragraph. In conclusion thereof, as such, accordingly, the impugn order and the consequent extension order dated 19 July 2024 shall not be given effect to by the respondents, and they are directed to immediately examine the matter afresh by affording opportunity to the writ petitioner. Stop. It is provided that till such matter resolved, the administration of villages will be taken care of by a person to be appointed by the executive committee as acting Gura. Stop. Next, a copy of the extension order, which has also been interfered with, dated 19 July 2024, is taken on board and paid marked the record and marked as X. It is expected that the entire exercise be completed within the month of January itself.
One more thing, my lord. If there is any complaint pending against the petition, that also
yes, no, that's what,
that can be considered by us.
Yes, you examine the whole matter.
Well,
that's what, yes.
Much obliged, Lordship.
Item 30.
Please, Your Lordship. Lordship, as the learned DHI is before Court number 1, Lordship, I brief this matter may be taken up on Friday or at the end of the board, Lordship.
This is what, which matter?
Lordship, this is dumping of soil into my agricultural land, Lordship. And it is a part of
Friday, you'll be here.
Not on Friday, Your Lordship. Next week, Your Lordship.
Next week, there's no time.
Or after vacation, Your Lordship.
Friday,
after
Lordship.
vacation, Your Lordship.
Friday.
Friday, I'm not here, Your Lordship.
Because, Lordship, I'm
how
not
culpable are you in this matter, or how liable? Sorry.
Lordship, they may shift a blame to us also. So, Lordship, we have filed the affidavit, Your Lordship.
Was the inspection conducted by the revenue authorities together with the
no, only
NHIDCL?
the NHIDCL.
Then we can't dispose of this matter right now. Let's ask for report from the EDC, who do a report together with the NHID with regard to the extent of damage done.
Lordship.
And if we're imposing strict liability, then they'll be liable to compensate to a certain amount.
Lordship.
In line with early judgments of this court.
We come after vacation.
They'll count vacations then.
Lordship.
Just in view of the absence of the. Otherwise, we'll have it on Friday. We'll issue directions
Lordship,
for.
I'll not be here on Friday.
Then who's going to be there? She'll be there.
Let's come after vacation, Lordship.
Monday.
Monday. Offline.
Due to absence, due to the unavailability of the DHI, let's meet on Monday.
Offline, Lord.
31.
Yes, Mr. Kumar.
My lord, the petitioner is aggrieved by non-consideration of his promotion to the rank of Naib Subedar, my lord. What happened in the month of March 2020, my lord, he was sent to the ARE duty, my lord, in the headquarter 9 sector, my lord, in the same organization of Assam Rifle. And
is a covered case, where's the judgment?
Yes, my lord, I have annexed that, my lord. Kindly see.
MS Guru, you know about this case?
Yes, Your Lordship, but then
Kindly
I'm
see
little handicapped without in absence of my senior.
page number
Lordship.
23, my lord. Annexure
Lordship,
6.
if this matter may be taken up at the end of the board, Your Lordship.
Out of some time.
My lord.
Much
Keep your lordship.
32.
Your Lordship, I pray for some accommodation, Your Lordship.
What's the matter about?
Lordship, it's a very, the matter is simple, very small issue. Issue is that, Lordship, they are not giving me one increment. I have already treated from the office of the DGR.
but I was entitled for one increment, but they are not giving. They are denying on citing some rules, but it was overruled by the Honorable Supreme Court also, Lordship.
No,
So
it's
it
not
is
after vacation. You can't argue with this. Yes.
Much
After, due to unavailability of the DSGI list after vacations. Yes.
33.
They'll require hearing. I mean, this one, that's fine.
Also, this matter also may be taken up after vacations. In fact, we made a mention in the morning, but respondent was not present.
The request of the concern was after vacations.
34.
Yes.
Lordship, agency.
Can you manage the seat?
Lordship, our instructions said that they had asked two medical colleges also.
Only
if
two.
they
There
were
were two we know, that King
But-
George and the other
yes,
one,
Lordship, but
and
the
the
thing
regional
is-
level college.
Yes, Lordship. So what our instruction says is that there's been no response so far, and moreover, with regard to the accommodation for next year, so Lordship, that would depend on her NET scores because that is a condition in order to come in the merit list.
It's, if I may just add, the fact that they're saying that the need score will be necessary, that may not be relevant because they've not consulted this particular judgment, which I was referring to on the last date. If your lordships by judicial order reserve a seat for the private respondent number 5, I don't think it will be necessary for him to sit for the NEET again.
Paragraph 13.2.
13.2.
Well, the judgment is 2020-17 SCC 465.
No, in that judgment, the thing is that the person who got deprived of seat came to court.
Yes.
Very
yes,
promptly.
Yes, yes.
And here also.
So here it's the other way around.
Oh, yeah.
Yes. 13.2.
Yes.
Hello. 13.2 and 13.3.
Yes.
Because until 11
So in fact, if had I not come to court, in fact my learned friend would have had to come to court.
Should have come.
It's okay.
But we corrected our mistake, Mr. Millard. Corrected our.
You made your SOP.
Why? Because he was my friend's client was meritorious. We cancelled the admission of petitioner. Then petitioner rushed to the court saying that I have already been admitted, and because of your lordship has seen the file.
Yes. It is a genuine.
Yeah.
So there's just one distinction, Lords. What I notice in all these cases, the requirement is where a person is featured in the merit list and he's been deprived, but he never featured in the merit list.
Whatever it is, but
he came a
from
little later.
From the records,
That's-
it's like, they.
Yes,
it's,
yes,
it's, See, it is through no fault of the respondent.
Yes, yes, absolutely.
He had put his application maybe.
Correct.
Albeit a little later. Now they should
Yes.
have. You see, they should put a cutoff date.
Correct. Yes,
That
sir.
we receive because it's for specialization.
Yes.
So all those dental.
Yes.
They should even if
On the
circulated
website,
among
website.
whatever that there's a cutoff date for for applications, then we'll solve this
The
problem.
lordship,
Now you've already taken applications. They come a bit late nowadays. You can't bar them also because there's no cutoff date.
Yes, precisely.
Your lordship, in MBBS, the similar issue came, and the order has been passed. If the similar order can be incorporated
By which court?
by this court only.
She opted for.
No, but my notification of that. No, that is with regard to Milord, the notification dated so and so for MBBS seats allocation. Paragraph 2, Milord. Can you see paragraph 2?
Yes. Oh yes. This is very relevant.
Yes.
Yes. Sit down. You try to make it as brief as possible. the petitioner, or the brief facts surrounding the case are that the petitioner had applied for Master of Dental Surgery bracket MDS, and then after another bracket PG course against the seats allotted to the state of Meghalaya, against the seat allotted to the state of Meghalaya at the Regional Dental College Guwahati for the academic year 2024-25, along with 6 other candidates. Stop. As per the set list, the petitioner having obtained the highest NEET score, NEET score, she was nominated to said vacancy, and after complying with all necessary formalities, was admitted to said postgraduate course for the academic year 2024-25 on 22/7/2024, and classes had then commenced. Stop. The grievance of the petitioner's para is that the state respondents, via an order dated 19/8/2024, unilaterally withdrew her nomination for the MDS PG course against the seat allotted to the state of Meghalaya on the ground that there existed another candidate with a higher NEET score as per second list, which had been submitted to the state respondents on 29/7/2024, and that the private respondent, the other candidate bracket private correspondent here, and that private respondent, oh, you pleaded yourself, or you were already there?
No, he was already there.
Yeah, and the private respondent, higher NEET score as per second list. PG course, state of mind. There existed another candidate bracket respondent number.
Respondent number 5.
Bracket respondent number 5 with a higher NEET score as per a second list, which was as per a second list submitted to the respondents on
19th August 2024.
29/7/2024, and as such, by the impugn order or by another order, the para respondent was nominated against a seat already occupied by the petitioner in the same college. So, next paragraph, Mr. SN submits that, has submitted that the petitioner, having been allocated the seat validly on her application and being the most meritorious as per the list released by the state respondents on
22nd
22/5/2024. Therefore, acquired a vested right to the seat and the unilateral cancellation without affording a opportunity of hearing or a hearing to the petitioner was illegal, and it was illegal, arbitrary and illegal. So, it is further submission. It is further submitted that once the seat had been allotted to the writ petitioner, notwithstanding the fact that other meritorious candidates are present, however, once the order had been issued, the state respondents were stopped from retracting the same. Stop. Such he prayed that the allotment of the MDS PG course seat to the private respondent at her expense be set aside. So, next parameter, the Lieutenant Advocate General appearing for the state respondents has submitted that the reason for the issuance of the order recalling the allotment of the seat to the petitioner was due to the fact that after the earlier applications had been processed, fresh application had been received from the private respondent and others, and as the private respondent was having a higher need score, the state respondents had resorted to the action which is now impugned. Stop. In this context, or had been last sentence. Have been received. To the action which is now impugned in the present petition. So, it is further submitted that the recall of the private of the writ petitioner's candidature was only due to was only not to deprive a more meritorious candidate was available for consideration. So, then private respondent.
I state that prior to her allotment of the seat, affidavit at page 17.
Yes.
On 2nd of July, the DHS has issued, has informed the state government, health department.
Where is that?
Page 17 or page 11 of my affidavit.
Yes.
This is dated 2nd of July, before the seat was allotted to her. It was received on 8th of the bottom, on the 5th of 8th.
No, page 11.
Page 11 of my affidavit.
No, but 19 August she joined on. She already joined. Start on first.
No, because your lordships had recorded that the DHS has communicated only on 29th of July. That is after her allotment. But actually, the communication was before. Communication of second list was before the.
But decision was taken prior to receipt of the application, my lord.
I'm just pointing.
Yes. No, submitted 29/7 and communicated on 19 July to you. 19 August. That
19
I'm
August
referring 29/7, not 29/8.
No, Lord. Can you have page 11?
It's 19th August.
The decision was to grant admission is on 19th August only.
2nd of July, Lord.
Your page 11, which your affidavit, right?
Lord, kindly have the state's affidavit. I'm so sorry.
Oh.
The state's affidavit.
Then be clear, Liz, otherwise.
I'm so sorry.
Yes.
So the first communication on 2nd of July. At the bottom received on either 3rd or either 5th of July. Subsequently, yes. On the next page, again dated 26th of July or 25th of July, received on 29th of July.
Yes.
And her allotment was in between, that is 15th of July. So my name was sent before the allotment.
Mr. Philemon Nombri, a paid correspondent, submitted that the request for admission for MDS course was made much prior to the allocation of the seat, to the to the writ petitioner and has referred to annexure R1 and this 12 is what? R2. And as a for R1, which is letter date 27. Sorry, Mr. Philemon. Start again. This got derailed a bit. On 2/7/2024, and has referred to annexure R. This is R1. Can make out R1. Yes, thereof which of R1 of the state as affidavit. To substantiate this fact, the councils also referred to annexure R2 to show that copies of a petition received from the private respondent had been received by the concerned authority on 29/7/2024. So he therefore submits that the petition, the respondent being more meritorious and due to no fact of his having been deprived of the seat deserves some consideration. So, next paragraph. This court, in the course of hearing, as it appeared that there was some, there was some anomaly in the matter of the allotment of the seat to the writ petitioner, had directed for the production of the original records dealing with the entire matter. Stop. A perusal thereof, however, has reflected that the entire exercise which had resulted, reflects that there was no malified intent in the entire exercise that had been conducted for admission to the said MDS seat. As per the note sheet, it is reflected that there is no set process followed, nor no deadlines prescribed for receiving applications, and no systematic counseling process practiced. So the seats are allocated based on applications received from the candidates, as very few applicants apply. Stop. It is seen from the record that applications were received in 2 lists on separate dates for the same seat, and the writ petitioner, as appears on record, was approved from the first list, which had been then communicated to respective college. It is further reflected to records that second list was forwarded by the DHS at a later stage. A later stage, we had candidates with higher need scores who had then submitted representations. Stop. It is further seen from the records itself that the state respondents have realized the need to keep a process, have realized that it is essential to keep a process for the selection of candidates for PG seats in dentistry, like the department does for MBS seat allocation. Stop. a further perusal of the records thereof then show the further action that been taken, which has resulted in the cancellation of the stated petitioner. Stop. As observed earlier, though there's been an anomaly in the allocation of the seat, however, there is no malified intent on the part of the respondents, and the entire exercise was done bona fide. For which, in the absence of a stated policy, blame cannot be the response cannot be no one can be held responsible. Stop. Next paragraph. In this view of the matter, notwithstanding the contesting claims of the writ petitioner by respondent, in order to balance the equities, and more so in view of the fact that the writ petitioner is already pursuing the course for a considerable period of time now. It is provided that henceforth for selection and allocation of seats for MDS, or for that matter any other specialization stream, the state government in the required departments, the state respondents, are to put in place and notify the methodology for selection of candidates. The Learned Advocate General at this stage has also produced an order passed by this court in WPC number 457/2022, wherein this court, on the production of our notification dated 4th February / 13 May 2022, which contain the methodology, had recorded the same in the order at para 2 thereof. Stop. In the instant case, the private respondent, due to no fault of his, has been deprived of pursuing the MDS course in the current academic year, and the writ petitioner, who had also been granted a seat in a bona fide exercise of power, in the absence of policy, has also acquired a vested right which cannot be ignored by this court. So, accordingly, at this juncture, next paragraph, it would be useful to refer to the case of so and so, reported in 2020 17 SEC 465, where in a similar case, the Supreme Court had this had a which Supreme Court had at para 13.2 thereof. Correct.
13.3 is with regard to the next academic session.
Yes, 13.3. Should we quote both the paragraphs? Only
My lord, both can be quoted.
Yes, and paragraph 13.3, 13.2 has held as follows. Stop. So in the present case, the respondent being more meritorious this court being measured in the considered view of this court deserves the same concession, that is, to the molding of the relief and direct for admission to be granted to such candidate in the next academic year into the MDS course without the requirement of need score being taken into consideration. Stop.
Lordship, 13.5 says it is related to MBBS, my lord. So that part.
Yes.
So we can be
Yes.
molded.
Yes, molded relief. It is further noted that though the judgment refers to admission MBBS course only, the same principle would apply to the instant case, which involves admission to postgraduate medical course. Stop. It is ordered accordingly. As a footnote, this court, before parting with the case, this court notes this one on he's ready to accept. Notes with appreciation the stand of the private respondent in accepting, in being ready to accept a seat in the next academic year for pursuit of his MDS degree. Repression on the above terms stands disposed of above direction stands disposed of.
With direction to the state, my lord, because the acceptance is there, direction has to be there by your lordship, saying that the student should be admitted.
Yes, that's already contained there. It's already given.
Same need score.
On the same need score.
Yes, I'll do it. We will correct that. Yes.
And also
records to be returned to the.
So my post is not disturbed. That's all.
Yes. Please take back the records.
Yes.
We will correct the order.
Yes. Fine.
Second poll 31.
Where's Dr. Mazika?
Lordship is still on legs, Your Lordship. Lordship, I therefore request if this matter may be taken up on Friday, Your Lordship.
Friday?
Friday. It can be disposed of, or otherwise covered in
that because if it's going to dispose of, he has to appear.
Yes, Your Lordship.
That's the thing. Yes. Friday, okay.
My lord. Deeply held, Lordship.
Much obliged, Lordship.
On the request of the MS R. Gurung on behalf of Dr. Moses is not available, who's on legs in court number 1, let the matter stand over to Friday.
My lord.
You can appear virtually also, no problem.
My lord. Much obliged, Lordship.